This is Radio Now 95.3 FM. Come for the news, stay for informed conversations.
President Bola Ahmed Tinubu has asked the Supreme Court to dismiss the suit filed challenging the suspension of all the elected officials of Rivers State under an emergency rule. The suit was filed by 11 states which are governed by governors from the People's Democratic Party, the PDP. Now, joining the conversation this morning to provide an explanation of the federal government's point of view is Justice Ojieno, who is a legal practitioner. Mr. Ojieno, good morning. Thank you for joining us on the conversation.
Good morning to you. It's my pleasure.
So, Mr. Ojieno, if we look at the counter that's been filed by the Attorney General of the Federation, right, he first says that the Supreme Court, he challenges the Supreme Court's jurisdiction to entertain this particular suit. Can you explain that for us? What exactly is he saying? What does it mean?
Okay. As lawyers generally, when people bring an action and we fall on the side of the defendant, and it's not unique to Nigerian lawyers, it's the same everywhere in the world, to the best of my knowledge. One of the reactions of lawyers is to file processes that will try to throw out whatever it is that the plaintiff has filed. And that's usually our first line of action. That's usually our strategy. We don't go straight to filing a defense in reaction to what the other party files. So I think, or I'm just thinking or finding that this is the situation. This is also what the Attorney General is doing in this case. And one of the things that we usually do is to challenge the jurisdiction of the court. We'll bring this, we'll say for this reason and for that reason. And in the present Attorney General's situation is saying that the court does not have local standards to actually decide the matter. And he's also arguing that it's an abuse of court process. So for the generality of the people, they may think that it's another thing, but for us, it's just our first aid. Usually, 99% of the cases where in actual fact it's the lawyer that is involved in litigation that is actually handling the case. So it is a very well experienced lawyer. It's usually one of our talking pages. One of the things that we'll do first.
You know, he also challenges, the government is also challenging the right of these states to bring the case before the Supreme Court. So perhaps you can flip that for us. Beyond challenging the Supreme Court's jurisdiction, challenging those who have brought the case against them, what exactly is the argument there?
Okay, it's almost the same plan. The argument there is that the district is not between the federation and state. It's pursuant to Section 232 of our Constitution. And that is when you have to remember that that's when the jurisdiction of the Supreme Court can be activated. There has to be a dispute, and it has to be between the federation and state. So, and his argument is that it is not, the present dispute is not between the federation and state. And we must remember that this Section 232 talks about the original jurisdiction of the Supreme Court as to when it can be activated. Ordinarily, if a state is if parties want to sue each other, the matter is not supposed to start at the Supreme Court. The Supreme Court is the ultimate appellate court in Nigeria. So because of that, they don't bother themselves with the trial part of cases. Trials are supposed to be conducted, rigorous trials are supposed to be conducted before the trial court, which by default is either the magistrate court, the customary court, or the federal or state high court or national industrial court, as the case may be, because the trial part of cases is very, very cumbersome and it's a bit technical and it is for a trial judge to handle. So because of that, more specialized and less cumbersome jobs, but more technical jobs are left for the appellate court to handle. That's what the Court of Appeal is for. That's what the Supreme Court is for. But because of the sensitivity of matters that involve federal government and state government, and the fact that alacrity is often needed, that is why the original jurisdiction of the court, of the Supreme Court, is invited in their cases, and the Supreme Court is now made to be a trial court in their cases. So because of that, the Supreme Court, the Constitution wants it to be that it must be a matter, indeed, there's a dispute between as little a number of parties as possible, which is the federation and state, and that's why Section 232 is there, because at this time, the federal court or the normal trial court in the court of events will not have the first bite at the apple. It will only be the Supreme Court. So that is why they are now saying that this is not one of those cases ordinarily, and what that means is that the parties will go and slug it out first at either the federal high court or at the state high court, depending on which one has jurisdiction. Then the matter will flow to the Court of Appeal, then it should now flow to the Supreme Court, but not to start at the Supreme Court. And this goes back to what I said in my opener, that as lawyers generally, especially as defense lawyers, we bring everything in the book, either delay the case or to ensure that the matter is thrown out from the beginning without having to bother us. So that may be some of the strategies that is being deployed by the Attorney General in this case. And by no means am I saying that he has a case or he does not have a case. At this stage, I can't do that, because it will amount to subjudice or prejudice, depending on how you slice and dice it. So, but this is our stock in trade as lawyers. We will bring applications before the court. So the court will either to throw out the case or to carry out our intention of delaying the case.
So, Mr. Ojeno, we're wrapping up the conversation with this next question. In a counter such as the federal government has offered, is it required to bring counter arguments against every point that's been raised by the plaintiffs?
Yes. And of course, it's in line with Section 36 of our Constitution that talks about fair hearing. If the plaintiff in this case brought a case and the defendant has reacted, the court will now check in the defendant's reaction, did he raise new issues? If the defendant raised new issues, that is what that's when the plaintiff again has a right to actually react solely to the new issues that have been raised by the defendant. So that is the way it plays, because fair hearing again goes to the jurisdiction of the court. If the court does not give fair hearing to both parties, if both parties are not allowed to present their cases and respond to the cases that have been alleged either originally or afresh by one of the parties, then it goes to the jurisdiction of the case. And jurisdiction is a very, very dangerous issue that can be raised at any point, even at the Supreme Court, orally. And if it is raised and it is upheld, the court will throw out the entire case. So it's a poison chalice that every court in the land, they are extremely, extremely careful about. And it is something that they give their utmost attention, because they know that if they don't give their utmost attention, no matter how fantastically conducted the case is, no matter how many senior advocates, no matter how many years the matter lasted in court, the matter will be thrown away.
Right. Mr. Ojeno, thank you very much for your time on this conversation. Justice Ojeno is a legal practitioner who joined us this morning to speak or to explain the arguments of the federal government regarding the suit filed challenging the suspension of all elected officials from Rivers State under an emergency rule. Now, this suit, of course, is filed by 11 states which are currently governed by representatives from the People's Democratic Party, the PDP.
This is Radio Now 95.3 FM. Come for the news, stay for informed conversations.